All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores,
Present.
Senator Orenshaw, Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
And I am here. Please mark Senator Orenshaw absent excused. He is presenting in another committee and then chairing another committee. And please mark Senator Wynn present when she arrives or absent excused if she is also away doing other important Senate business, which I know that she is. That's why she's away. And with that, I will open up the hearing on AB 369. Just wanted to flag for our members that there is an amendment on Nellis. It is not long or complicated, but I just want to make sure that you saw that before our presenter begins. And please go ahead whenever you're ready.
Thank you so much. Good afternoon, Chair Scheibel, Vice Chair Flores, and members of Senate Committee on Judiciary. My name is Shay Backus, and I have the pleasure of representing Assembly District 37 in Northwest Las Vegas. Thank you for the opportunity to present Assembly Bill 369. Assembly Bill 369 is a bill that helps ensure the protection of Native peoples in our state. It follows from my work in the last legislative session to address missing and murdered Indigenous persons crisis. Last session, through AB 125, we ensured that when Indigenous persons go missing, that state police could take a report and capture it into the National Crime Information Center. This was important as many tribes do not have tribal police or have access to the National Crime Information Center. For those tribes that rely upon the federal government for law enforcement, there are also delays in the arrival of a BIA officer. Additionally, AB 125 created a tribal liaison for the Department of Public Safety. Nevada law recognizes that our Indian tribes within our state possess the power of self-government to enact their own laws, regulations, and ordinances, and enforcing them by their own tribal courts in accordance with their rules of procedure. So according to an article published in American Constitution Society for Law and Policy, American Indian women residing on Indian reservations suffer domestic violence and physical assault at rates far exceeding women of other ethnicities and location. American Indian women experience physical assaults at a rate of 50% higher than the next most victimized demographic. In all, 39% of American Indian women report being victim of domestic violence. Missing Indigenous persons are not in a silo in Nevada Indian country. An exemplar of this is Anna Scott, who is a member of Pyramid Lake Indian Reservation, whose body was discovered on February 3rd, 2022, in the trunk of a car set on fire on I-580 between Reno and Carson. Over 3 years later, her murder has not yet been resolved. After last session, I attended a MMIW conference in Elko. About 200 individuals from state, local, tribal, and federal were in attendance. This task force basically held seminars where we all got together and were able to discuss ways to address victims of domestic violence, especially those in Indian country. And basically it came from that session through a task force that where there was a need was to assist with making sure that temporary restraining orders that are issued in Indian country are likewise enforced off of the reservation. Because what was happening is most people may live in a tribal community that abuts a regular city, and so you may be shopping or working off of the reservation. It was to make sure that victims of domestic violence were protected under their temporary protection orders. And I feel like this committee is small and mighty and very intelligent, so I probably don't need to explain what full faith and credit is or what protection orders are. So I will skip that part and move on to what the purpose behind AB 369 is going to do. So basically, in order for TPOs to be enforced, the order must first be recognized as valid. This AB 369 expands the evidence to an officer may use to determine a valid protection order on its face to include digital evidence. This is so enforcement of protection orders is not reliant on a physical copy of the order being present. This also allows officers to consider statements made by the adverse party of the restraining order to count as evidence in court. Another significant challenge in enforcing protection orders is that the respondent must be given sufficient notice before the order can be enforced. After discussing the language with stakeholders, I will submit that the language should be slightly amended, but there may be more of amendment because I received a communication from legal that my little proposed amendment that I thought could clean it up may not be doing what I intended. So the key is for the intent behind the change is that officers should be able to confirm that there was service. And if there was not service of the restraining order, then the steps would follow to allow an officer to serve the protection order. So with that, I'd be happy to walk the committee through the bill. It's pretty short. In section 1, subsection 4A, this affirms that the digital copy of a protection order can be provided as evidence to an officer. Section 1, subsection 4D allows any statement by the person against whom the order is being enforced to be relied upon by officers when they are enforcing an order for protection against domestic violence. Section 1, subsection 5 introduces a process for law enforcement officers to follow when an otherwise valid order for protection cannot be enforced because the respondent has not been notified. The process outlined in this subsection would require 1, officers to verbally inform the respondent, which would be taken as sufficient notice. 2, make a reasonable effort to serve the order to the respondent. And 3, allow the respondent to reasonable period of time to comply with the order. This is crucial to protection of Indigenous people as it introduces an official channel for valid orders to be enforced. Section 1, subsection 6 requires officers to document any actions taken regarding subsection 5 and cooperate with the court the TPO was filed in for proof of service. Section 1, subsection 7 and section 1, subsection 8 make conforming changes. AB 369 is a critical step toward ensuring that Indigenous peoples, particularly those affected by the MMIW crisis, are afforded the fullest extent of protection under Nevada law. The challenges faced by victim advocates and law enforcement in enforcing tribal protection orders must be addressed so that victims are not left vulnerable due to procedural gaps. This bill will reaffirm the full faith and credit given under NRS 33.085, which has been already a part of our law. By modernizing enforcement procedures, expanding acceptable forms of evidence, and introducing a structured process for notification, this bill closes loopholes that have allowed abusers to evade protective orders. AB 369 is about more than legal reform. It is about justice, safety, and recognizing the sovereignty of our tribal courts. I urge your support for AB 369 so that Nevada can take meaningful action in protecting Native communities and ensuring that all protection orders, regardless of jurisdiction, are honored and enforced. I thank you for your time today, and I stand ready to answer any questions the committee may have.
Thank you so much. Are there questions? We'll start with Senator Lang.
Thank you, and thank you for the presentation. I think this is a really good bill, and I'm not a legal person, so I'm just going to ask this question just because I'm curious. In section 1, number 5B and C, it uses a word reasonable. And so could you tell me what reasonable means to you? And I'm just curious if it wouldn't be better to put in a certain period of time, like a day, 24 hours, 48 hours, or something like that. So if you could help me understand.
So when I think of reasonable, I think what a reasonable person would do in the same situation. But in this situation, it's not intended for our officers to try to go out of their way to serve the order. The whole point of it is when they're in this situation where, say, you have 2 individuals, one who is the victim of domestic violence who has secured a temporary restraining order from a tribal court, and they're seen and there's an incident that's off of the jurisdiction of Indian country, like for example, like if it was in Fallon and the Fallon tribal court had issued a protective order, but you're in the city of Fallon going to the grocery store, or the victim is at work and they work off of the tribal community, and a cop comes up and is engaging with them, and she or he explains that they do have this TPO, that I think it's more of a tool for the officers to de-escalate what's going on right then and there, and not intended for the officers to have to follow up down the road to go, okay, we're going to go serve this. But it also could be a vehicle where it could be service. There are situations where victims in Indian country secure a restraining order and the perpetrator intentionally leaves the Indian community to avoid service. So this could be arguably used as a vehicle if they wanted to use it. But I looked at it as more to de-escalate the situation, because the last C would allow the respondent a reasonable opportunity to comply with the order before enforcing it, to allow them to leave the situation. I hope I answered your question.
Other questions from members of the committee? Senator Ellison.
I'll make it real quick and easy. I did some research on this a long time ago, and I was shocked to know how much rape was out there on some of these reservations. And so I talked to a friend of mine, and she said not only was she raped, the next night her daughter was raped. And we don't know if it was by the same guy or not. But the problem was, I had no idea it was that bad. But the other question, or that's not a question, it's a statement, but the other thing I got is, is under federal law, you know, if there's a domestic violence, then you're protected by, the judge can remove any kind of weapons in the house that belong to that person, unless they're the wife or somebody's got them locked up. I don't know if that falls under why they're on reservation land or not. Could you answer that? I don't know, because it's still under federal law, so I don't know. Usually state and counties have their own, but.
Senator Ellison, Shay Backus. I realized the first time I didn't say my name for the record. Shay Backus for the record, by and through Chair Scheibel, to the Senator.
You can go direct, please.
Thank you so much. You've asked a lot, and I want to kind of touch on it. Your quick, simple question. First, your community is also another community where there is a situation where you have the Elko Banatamook Indian Reservation right there right in the heart of Elko, actually. And there's interplays with criminal jurisdiction, but one of the really heartening things that's happening right now is if our tribal communities are not able to have self-determination and have their own tribal police, they have to lean in on federal officers to enforce laws, criminal laws. And I think it's like our well ban. I can't remember which of the Tamuk tribal reservations that I went to, that actually they leave their tribal officer car parked outside even though they don't have tribal police, but people know. And so you can easily become a victim, and it's tough because obviously out of respect for the government to government relationship, our local law enforcement cannot go into Indian communities to enforce laws. And so what happens is a victim in a situation where you could have victim back to back, it could take that long for the BIA officer to get out to one of our reservations. There's word that our western BIA office out by you is going to get shut down. That's going to make things even worse because our next BIA office is in Carson City. So to get out to Oahe, for example, could be over 8 hours, and that's if they're available. And so I mean, that's a whole other issue. The question you did ask was whether or not this situation with guns. So when you're looking at criminal jurisdiction, the tribe has jurisdiction over crimes that are usually like misdemeanors or up to 6 months in jail when it's between an Indian and an Indian. There's a lot. I could go through my whole criminal jurisdiction that I wrote to make it in 1 minute, but it's pretty convoluted. And so you would have to look to two things. One is if there's tribal law in place that would pertain to each of our different 28 nations, or in this situation, if there was federal law that would cover it, and it may under VAWA. I'm just not familiar with that, and whether it would allow for the removal of guns. I would assume under VAWA, maybe it would, but you would need a BIA officer out there to enforce, or a federal officer like an FBI agent.
And then we had a FBI involved in a place up in Ely for a child that was murdered in the FBI agents are still in Elko, did they still have jurisdiction to go on the tribe, do they not?
Thank you, Senator Ellison, for the question. Shay Backus for the record. So that is a perfect example. The FBI agent in Elko would have jurisdiction when there is a murder to go onto the reservation to do the investigation.
Thank you very much. I appreciate it. I like the bill, and I'm glad it's here. Thank you.
Other questions from members of the committee? All right, I don't see any questions, so thank you so much for your presentation and for answering our questions. We'll move now into testimony, starting with testimony in support in person for AB 369. Please come on forward to provide testimony.
Good afternoon, Chair Scheibel, members of the committee. Thank you for the opportunity to testify. For the record, my name is William Horn with Western Public Affairs, representing Safe Nest, Nevada's leading anti-domestic and sexual violence organization. I'm speaking in strong support of AB 369. This bill represents a critical step forward in addressing economic justice. For decades, the anti-violence movement has recognized that poverty and financial controls are core tools of abuse. Tying financial penalties to ability to pay ensures we are not compounding the harm survivors already face. This bill also measures systemic barriers to safety and accountability. Survivors of violence are often trapped between seeking help and the risk of further destabilization. Reducing the waiving fees for low-income individuals means fewer will be forced to choose between court compliance and basic needs. Informing individuals of their rights and eliminating the cost to request waivers to reflect a trauma-informed approach rooted in procedural fairness, values long championed by the anti-violence movement. This bill here helps in doing these things amongst others, and these protection orders are important, including in our tribal lands that we have many of in our state, and I stand fully in support of AB 369. Thank you.
Good afternoon, Chair Scheibel, members of the committee. Jason Walker, JasonWalker, representing the Washington County Sheriff's Office, supporting Assembly Bill 369 as amended. We have run into these instances on numerous occasions where we're unable to confirm an otherwise valid order. This bill, as amended, pretty much mirrors our standard practice if we're unable to confirm. We are appreciative of the efforts of Assemblywoman Backus.
Good afternoon, Chair and members of the committee. My name is Joshua Martinez. I represent the Las Vegas Metropolitan Police Department. We are in support of AB 369 as amended, and we echo our support that the other previous speakers had. Thank you.
Good afternoon, Chair and members of the committee. My name is Shelby Beetz, B-I-E-T-Z. I'm here on behalf of the University of Nevada, Reno. We want to thank Assemblymember Backus for bringing this bill forward. AB 369 will help support the enforcement of domestic violence protective orders across various communities in Nevada. For the last decade, Nevada has ranked in the top 5 for domestic violence fatalities. Unfortunately, since 2016, the number of protective orders granted to survivors has been decreasing, leaving survivors at an increased risk. This bill will assist to remove one barrier to protection from risk of fatality following domestic violence. The University of Nevada, Reno's extension, Hope for Family Resilience programs provides education to individuals, law enforcement, first responders, support, and care providers to become advocates for change against domestic violence. AB 369 further supports ongoing efforts across Nevada between tribal communities, law enforcement, and the University of Nevada, Reno, and others to ensure that when protective orders are granted, they are enforced consistently for survivors across the state. Thank you.
Sir,
Sorry,
if you break it, you buy it.
Oh, man. And I can't afford it, Chair. I really can't. But good afternoon, Chair, committee, staff, my name is Zach Bucher from the great city of North Las Vegas. Here today in support of this bill. This bill makes a lot of sense, especially for a transient state such as ours. We believe it will protect people in our community, and for that reason, we're here in support. Thank you.
All right, thank you so much. I don't see anybody else coming forward to give in-person support testimony on AB 369 in either location, so we'll go to the phones, please, for support on AB 369.
Thank you, Chair. If you would like to testify in support to Assembly Bill 369, please press star 9 now to take your place in the queue.
Good afternoon, Chair and members of the committee. My name is Riley Svensson. That's RYLEY SVENDSEN, and I am the policy specialist with the Nevada Coalition to End Domestic and Sexual Violence. We want to thank Assemblymember Backus for bringing this important bill forward as it decreases barriers for Indigenous victims, and we're grateful for Assemblymember Backus for always prioritizing the most marginalized communities when it comes to violence prevention and equity, and we urge this committee to support the bill. Thank you so much.
Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Matilda Miller. That's MATHILDA, MILLER, Government Relations Director of Native Voters Alliance Nevada, and I'm here in strong support of Assembly Bill 369. At its core, this bill is about one thing, and it's about ensuring that our relatives are afforded the fullest protection of the law. Native women face some of the highest rates of violence in this country. They are targeted, they are harmed, and too often they are left without protection. This bill changes that and it's a step towards ensuring that our relatives are protected, and it closes dangerous gaps while honoring tribal sovereignty and protects lives. We thank Assemblymember Backus for putting this bill forward and for her unwavering efforts to continue protecting our relatives and ensuring that they receive true justice. We urge your support. Thank you.
Chair, there are no further callers wishing to provide support and testimony at this time.
All right, then we will move to testimony in opposition to AB 369. Anybody wishing to give opposition testimony is invited forward to do so now. I don't see anybody coming forward in person in Las Vegas or Carson City, so we'll go to the phones for opposition testimony on AB 369.
If you would like to testify in opposition to Assembly Bill 369, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to provide opposition testimony at this time. Thank you.
All right, thank you. We'll move then to neutral testimony. Anybody wishing to give neutral testimony on AB 369 is invited forward to do so now. Not seeing anybody coming forward to give neutral testimony in person, we will go to the phones, please, for neutral testimony on AB 369.
If you would like to testify in neutral for Assembly Bill 369, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to provide testimony in neutral at this time.
All right, then, unless the sponsor has any closing remarks, which she does not, that brings us to the end of our hearing on AB 369. I will close the hearing and open up the hearing on AB 480. Welcome to Senate Judiciary.
Good afternoon, Chair Scheibel, Vice Chair Flores, members of the Senate Committee on Judiciary. My name is Steve Yeager. I represent Assembly District 9, which is down in southwest Las Vegas, and it is a pleasure to be in front of this committee for the first time this session, probably not the last time, but here this afternoon to present Assembly Bill 480 in its first reprint. This bill aims to adopt the disparate impact standard for purposes of the Nevada Fair Housing Law. And Chair, with your permission, I'll give some brief background information, then I'll go through the bill. It's not all that complex, and then I'd be happy to answer any questions. So by way of background, unfortunately, housing discrimination still remains a persistent issue, not just in the state of Nevada, but across the country. Assembly Bill 480 seeks to strengthen our existing fair housing laws by adopting what is known as the disparate impact standard. This would align Nevada's protections more closely with current federal regulations. Under the Federal Fair Housing Act, the disparate impact standard is a critical tool in combating housing discrimination based on race, color, religion, sex, handicap, familial status, or national origin. It allows us to address policies that may seem neutral on their face, but in practice result in discriminatory outcomes. I'll give one example. A landlord might enact a policy of evicting tenants who call emergency services more than twice in 6 months. That might seem like a neutral policy, but in actuality, it may disproportionately impact women who are victims of domestic violence. So while not explicitly discriminatory, such a policy creates barriers for women seeking housing. The disparate impact standard recognizes that discrimination often occurs not through overt statements, but through policies that drive unequal outcomes. It enables us to hold accountable those whose practices perpetuate housing segregation or disproportionately harm protected groups, even without proof of discriminatory intent. Now, I would love to tell you, Chair, that I came up with this idea all on my own to put this into state law. I did not. New York has proactively introduced legislation to codify state-level disparate impact standards and housing laws, mirroring the Federal Fair Housing Act protection. And so that is where I got this idea. I actually do read those emails we get every morning that talk about what's going on around the country, and I saw that New York did this, and my first question was, do we have this in our state law? And we don't. So that was the genesis of the bill. So this bill in front of you, or excuse me, the New York bill does much what this bill does, and it remains that the federal protections will remain in place even if they go away on the federal, from the federal regulations. So measures like this, Assembly Bill 480 and those in New York, are important because if we're being honest about it, the current presidential administration has launched efforts to dismantle the federal disparate impact enforcement, including a January 2025 executive order directing agencies to curb diversity, equity, and inclusion practices, and a United States Department of Justice memo narrowing disparate impact claims. And I know we all lived through the election that happened, seems like years ago now, but it was back in November of 2024. And Project 2025 was talked about quite a bit, and Project 2025 explicitly urges ending the disparate impact statement's use and challenges its constitutionality. I believe these actions risk gutting civil rights tools that address systemic discrimination in housing, lending, and employment. And the truth is we don't know what's going to happen with this, but I think it's pretty likely to assume that it's probably going to come out of the federal law at some point. Additionally, a question I have been asked is what if the United States Supreme Court decides that the disparate impact statement is unconstitutional? Well, if they decide that, then even if we pass this bill, it's going to be unconstitutional. So we don't know what's going to happen there, but I would anticipate probably a constitutional challenge in the near future, given how things have played out in the last 6 months or so. So I think by adopting this bill, we can have it as a vital backstop against federal rollbacks, preserving accountability for policies that disproportionately harm marginalized communities. This would align our state with long-standing federal interpretation of the Fair Housing Act and provide a vital mechanism for combating subtle forms of housing discrimination. And Chair, with your permission, I'll take you through Assembly Bill 480 in its first reprint. Section 1 introduces new provisions in Nevada law that establish that liability for a discriminatory housing practice can be based on either discriminatory intent or disparate impact on a protected group, even without discriminatory intent. I know not everyone on the committee is an attorney, but discriminatory intent is usually pretty easy to prove if you have emails where someone says we should enact this policy because we don't want certain people in housing. That's the easy case, and usually when you do discovery and lawsuits and you find that sort of smoking gun, you have a pretty easy case to prove. What we're talking about really here is the disparate impact statement, where maybe there isn't that smoking gun, but in practice it has a discriminatory impact. It also provides, though, there's an out here that there's no liability if the practice is necessary to achieve substantial, legitimate, and non-discriminatory interest that couldn't be served by a less discriminatory practice. And for you lawyers, this is the strict scrutiny standard that you may remember from law school, that you can in fact do this if there's no other way to achieve what you're trying to achieve and there's no other less restrictive way. And then Section 1 also outlines the burden of proof for both complainants and respondents in disparate impact cases. Section 2 incorporates this new section into the Nevada Fair Housing Law. Section 3 applies the definitions in existing law relating to discrimination in housing to the provisions of Section 1. And then Section 4 makes the bill effective upon passage and approval. Chair, I think the importance of this legislation cannot be overstated. It strengthens our ability to ensure fair housing for all Nevadans, addressing both intentional discrimination and policies that result in discriminatory effects. I was proud to receive bipartisan support for this bill in the Assembly, and I urge your support of Assembly Bill 480 in helping us take an important step towards fair and equitable housing for all Nevadans. Thank you, Chair. Thank you, committee members, and I'd be happy to answer any questions.
Thank you so much for your presentation. Are there questions from members of the committee? We'll start with Senator Ellison.
I do have a question. You see these contracts now, people are putting in there, if you rent to, say, a mother and father, and they have children, that's fine, that's not a problem. But if they're falsifying the contract to where they can get rid of their 18-year-old son and his friends, that creates a problem. Would that fall into this bill? Because you're trying to get them out of there because of the damage and destruction of the house. So,
Steve Yeager for the record. Chair, may I go direct to the member, or would you like me to go to and through the chair?
Please go direct.
Okay, thank you. Thank you, Steve Yeager, for the record. I don't think that would apply, Senator Ellison. This really is getting at sort of blanket policies where, for instance, the example I gave, where if you have a policy that looks like it's neutral on its face, but it actually results in discrimination against a protected class. In the instance you bring up, I don't think folks with children necessarily, I mean, they wouldn't be a protected class. It's just the protections that are listed in our fair housing law. So think about race, color, religion, sex, disability, natural origin. So I don't think so. And, keep in mind too, folks could make a claim that a policy resulted in a disparate impact, but you can't just make the claim. You actually have to go to court and prove that claim. So that would be part of what would happen as well. If someone wanted to claim that, they certainly could. They could file a lawsuit, or they could go to the Equal Rights Commission here in Nevada, but they would have to, make their case and show proof. So I don't think that example would fit under this bill, but ultimately I guess it would be up to a court to decide. Doesn't sound likely though.
I think what resolved a lot of these was, because they put it in their contracts now, that when the mother and father finds out they got to pay for $10,000 or $15,000 in damage, then they help move them out real quick. So that we're seeing that more and more and more all the time, and so that I know is an issue that's coming up. And there was another bill that was here just recently that you could not discriminate, and it was just like this kind of. But it kind of got into Jewish religion and everything else, and it was a good bill, and I think it passed and heading your way. So,
Steve Yeager for the record. Thank you, Senator Ellison. I am aware of that bill. I think it is headed over to the Assembly. So, I think we share this common belief, right, that we shouldn't discriminate in housing. And so all this bill tries to do is say there's overt discrimination, and we all know what that is. But sometimes there can be insidious motives that don't come out quite clearly, and so this gives an avenue for somebody to be able to bring a case based on that. But like any other case, they'd have to prove it to a judge or to a jury.
Other questions? Oh, Senator Hansen.
Thanks, Madam Chair. I kind of miss the days when you'd introduce yourself as, "Hi, I'm Steve Yeager. I'm the public defender for Clark County." Huh? Remember that? 10 years ago now. Well, congratulations on becoming the speaker. Okay, obviously I've got some issues with the bill. I'm sure you're shocked. So the genesis of the bill isn't problems in Nevada. It was a law that you saw that they enacted in New York, and because of the current administration's drift, you think we need to get this into law in Nevada. Is that kind of what I heard you testify?
Steve Yeager for the record. Always good to be in front of you, Senator Hansen. I miss those days as well. They were a little simpler than the days today, but
Amen.
Amen to that. I think half of what you said was correct, but there's some important context here. So right now, under the federal law, disparate impact is already something you can make a claim on. So it's not to say that it's not happening in Nevada. It's just there is a remedy now under federal law, but we don't have this provision in our state law. So my concern, very clearly my concern, is because Project 2025 says the federal government should get rid of this standard, that once it goes away federally, there wouldn't be any relief for Nevadans because now they can't avail themselves of the federal protection, and it's not in Nevada law. So really I would look at it as, at the moment, we would just be taking what is current federal standard and putting it into state law, but I want to do that because I think the federal standard is going to change.
I got it. That was you were clear twice now. Very good. Good attorney, getting it on the record twice. No, the question though is, do we actually have any cases in Nevada or federally of this happening in Nevada? You mentioned the Equal Rights Commission. Is there any evidence that they've had a complaint for somebody that got in trouble with their landlord because they called 911 more than twice in a 6-month window, as you used as your starting example of an unintentional act of discrimination?
Steve Yeager for the record. I don't know the answer to that question, to be quite candid. I haven't asked the Equal Rights Commission. I can ask that question if they've had any. The other thing that, Frank, would be a little difficult is, to know whether someone, because it's not just Equal Rights Commission, you can actually go to court and ask for an injunction too. So you have two different avenues here in the state. That's a little harder to figure out if that's happened or not, but I'm happy to make those inquiries. I don't know anything off the top of my head right now, but I do think it's important to be proactive. And, look, with all due respect to the political environment we're living in, I feel like we're at a moment in time where if we're going to start seeing practices like this might be the moment in time where we're going to see them, because in my opinion, and it's only my opinion, there's a little bit more of a feeling that folks can get away with things that maybe they couldn't have gotten away with before. I'm going to give folks the benefit of the doubt and say hopefully that's not going to happen, but if it does, I'd like to have this protection in state law.
Fair enough. In my mind, though, I think the direction of the country is going good. In fact, in Nevada, the current administration actually won, even though they were substantially outnumbered in registration. But rather than go down that rabbit hole a little bit too much here, the disparate impact federally, when was that law enacted? The current federal standard that you want to incorporate into Nevada law.
Steve Yeager for the record. Good question, Senator. I'll have to look at that. It's not in federal law, it's in federal regulation. Okay. So it was actually not codified, by congressional action. It was through regulation. I have the link here on my piece of paper, but it's not on my computer. So I can pull that up and happy to email back to you and to the committee to tell you exactly when that was.
You and I need to go to dinner anyway one of these days.
Steve Yeager for the record, we most definitely do, and we're running out of days.
Okay. All right. Well, the reason I ask that is, look, if it's been on the books for a while, what I'd love to see is there actually any prosecutions, any complaints, any of that kind of stuff. Because to put a law on the Nevada books now that is being possibly removed from federal law, one of the reasons it may be being removed from federal law isn't because necessarily we want to now allow some form of discrimination, but because there hasn't been any complaints, there haven't been any problems. The example you gave of the 911 calls, I just can't picture anybody actually getting prosecuted for that. No, maybe there are cases, but that's what I'd like to see. I'd like to see some actual evidence that this disparate impact problem is actually a problem before we see it removed on the federal level, but then incorporated in the state level, when in fact we're trying to create a problem that does not exist.
Steve Yeager for the record, I think that's more than a reasonable request, and I'll be happy to dig into that. I know there are a lot of resources out there where I can pull that together for you. And I did just want to make clear, I think the way that I would envision this playing out, because you said prosecuted, and it's not so much prosecuted. What would happen is, somebody has a policy like this, right, and then they end up evicting the tenant, saying, well, you violated the policy, but through that policy, what you're seeing is a discriminatory, a disparate impact. That person's options at that point would go to be to complain to the Equal Rights Commission or to file for injunctive relief, basically saying this policy is unenforceable and you've got to let me get back in my place. So I wanted to make clear there's no criminal prosecution. I mean, it would essentially be a civil case and almost certainly be when someone was evicted or if they applied for a rent or to live somewhere and they were denied based on a policy that they couldn't meet. So, but anyway, to your point, I'll get that information and make sure we get that over to you in the committee.
Very good, and I understand between civil and criminal, so civil obviously is a much lower standard, so I'd love to see what the actual evidences are that this is a problem worthy of putting into the state law in case federal law actually removes it. Thank you, Madam Chair. Great to see you again.
All right, other questions? I have one quick question. It seems to me like putting these protections or putting this standard into the Nevada law makes too much sense, because if nothing changes at the federal level, then nothing changes for the implementation in Nevada, right?
Steve Yeager, for the record, absolutely correct. I mean, if things stay as they are at the federal level, I mean, you still have the federal law, which is going to, sort of be the law of the land anyway. But I also think just there are some benefits sometimes when folks are working on these cases. They tend to look to Nevada law first. They pull up the NRS. And so if it's there, I mean, if there's a redundancy, there's a redundancy. But we're not doing anything here that's not already in federal law. There's nothing unique to it. It's just taking what's there and putting it into the Nevada Fair Housing Act.
Thank you. I appreciate that. All right, I think that brings us to the conclusion of our questions and on to testimony. We will start with testimony and support here in Carson City or in Las Vegas. I don't think there's any, I think there's someone in Las Vegas. I'm not sure if they're coming forward to testify. So we'll start in Carson City with in-person support testimony on AB 480.
Hi, good afternoon, Chair and committee members. My name is Jessica Munger, M-U-N-G-E-R. I'm the program manager for Silver State Equality, Nevada's statewide LGBTQ+ civil rights organization, and we are in support of AB 480. Thank you.
Good afternoon, Chair and members of the committee. For the record, Randy Robinson, Director of Government Affairs for the City of Las Vegas. City of Las Vegas is in support of this piece of legislation. We think it's important for our community and all communities, quite frankly. Chair, if I could also sort of speak in my private capacity as just a regular old citizen. A few years ago, while serving in a private capacity, I often was dealing with folks who were having trouble with landlords. And the types of issues that they brought, that often came across my desk were exactly the kind of issues that the speaker has been talking about, where it was not overt, but it was certainly a pattern designed to elicit a certain result. And so for that reason, in my private capacity, I think this is a good idea to get into our laws. Thank you very much.
Good afternoon. I thought I'd come back and give this microphone another try. Thank you, Chair, Committee. My name is Zach Bucher, great city of North Las Vegas. I'd like to echo the comments from my colleague and former boss from the city of Las Vegas. We're here in support. We believe this will be a tool that can help residents of our city. Thank you very much.
Okay. Thank you, everybody, for your comic relief this afternoon. And I still don't see anybody coming forward in Las Vegas, so we'll go to the phones for testimony in support of AB 480.
Thank you, Chair. If you would like to testify in support for Assembly Bill 480, please press star 9 now to take your place in the queue.
Good afternoon, Chair and members of the committee. My name is Riley Svensson, RYLEY SVENDSEN, and I am the Policy Specialist with the Nevada Coalition to End Domestic and Sexual Violence. We are here today in support of this bill, and we thank the Speaker for bringing it forward. Too often, victim survivors of domestic and sexual violence face housing insecurity, whether it's through nuisance orders or economic abuse. And to Senator Hansen's point, this is occurring in Nevada, and we do know that victim survivors have been evicted because of police involvement and police coming to housing and rental apartments. And we know that housing insecurity increases Nevadans' risk for violence overall. So we urge your support in AB 480. Thank you.
Chair, there are no other callers wishing to provide support testimony at this time.
Okay, we'll move to opposition testimony on AB 480. Anybody wishing to testify in opposition is invited forward now. I don't see anybody coming forward in person in Las Vegas or Carson City, so we'll go to the phones for opposition testimony on AB 480.
If you would like to testify in opposition for Assembly Bill 480, please press star 9 now to take your place in the queue.
Good afternoon, Chair and members of the Judiciary Committee. My name is Kimberly Fergus, Fergus. I strongly oppose AB 480. Nevada has enforced strict fair housing law since 1977. The federal fair housing law started in 1968, so we have really strong laws since 77. We already protect against discrimination. This bill just opens the door to abuse. Number one, no intent needed. This bill allows lawsuits without any proof of intent. A neutral policy like a credit check could be called discriminatory just because of how it impacts a group. Number two, it encourages gaming the system. People can cry discrimination with no real case, and an attorney will say, let's go get this guy. It invites lawsuits based on feelings, not facts. Number three, it punishes professionals. Landlords, realtors, HOAs will be afraid to act. Now they have to prove they're not guilty just for doing their jobs. And number four, it sets a dangerous precedent. If they pass in housing, it won't stop there. Insurance, banking, and employment will be next. It's a very slippery slope for activist lawsuits. We don't need this. Vote no on AB 480. Thank you. Have a good day.
Chair, there are no other callers wishing to provide opposition testimony at this time.
All right, we will move then to neutral testimony on AB 480. Oh, I see somebody in person in Las Vegas. We'll start there. Just let us know if you're in opposition or neutral, please.
May I go in opposition?
Go ahead.
Okay. CYRUS HOJJATY. I will echo the comments made by the previous caller. One of the concerns I may have about this is, I am for equal rights, but I'm just thinking that if I'm a developer and I sell homes and 90% of my buyers are a particular type of person, could I be in serious trouble? That's one of the things I just thought about. And obviously, I'm concerned about how this deals with private property rights, who they, freedom of association. So other than that, thank you so much.
Okay, I don't see anybody else coming forward in person. In opposition, so we'll now move to neutral testimony. Anybody wishing to give neutral testimony is invited forward to do so now, but I don't see anybody coming forward, so we will go to the phone lines for neutral testimony on AB 480.
If you would like to testify in neutral for Assembly Bill 480, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to provide neutral testimony at this time.
All right, then that brings us to the conclusion of testimony. If the sponsor, okay, I don't see any closing remarks from the sponsor. I do, however, want to pass it over to legal really quickly. They brought something up important, I think, Mr. Scully, actually, who is our other committee counsel. You guys don't normally see him here because he's normally based in Las Vegas, but we welcome you to the committee, and if you could provide a little bit more context, please.
Thank you, Chair. Michael Scully, for the record. I just wanted to bring attention to there has been recent action at the federal level regarding disparate impact. As of April 23rd, 2025, the President issued Executive Order 14281, which directs a rollback of disparate impact liability and similar requirements, especially sections 5 and section 6. Legal will have to take a look to see whether this applies to, how it applies to housing and urban development actions that could be brought, but just wanted to make everyone aware that that action was happening at the federal level.
Thank you so much. All right, and with that, we will close the hearing on AB 480. And that brings us to the last item on our agenda. Thank you so much, Speaker, for joining us. The last item on our agenda is public comment. Anybody wishing to give public comment in person is invited forward to do so now. I don't see anybody coming forward here in Carson City or Las Vegas, so we'll go to the phones, please, for public comment.
Thank you, Chair. If you would like to provide public comment, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting for today. We are meeting again tomorrow. We'll be back to our usual time at 1 p.m. Until then, we are adjourned.